Welcome to Landmark Chambers webinar, Planning High Court Challenges 2025. This is session 2, and we're delighted there's so many people who've been able to join today and are still joining. My name is James Maurici KC, and I'm chairing the session today, as well as speaking, and I'm joined by my colleagues Alex Goodman KC, Dr. Ashley Bowes, Ben Fullbrook and Siân McGibbon, who I will formally introduce to you in a moment. Just a few housekeeping points. Your microphones are automatically muted, so you don't need to change any settings. And we very much welcome questions. You can submit them via the Q&A tab that you should be able to find at the bottom of your screen. Enter them by text into there, and we'll try and answer as many questions as we can at the end, once we've heard all of the talks. The webinar is being recorded, and you will receive a link to the presentation and the recording shortly after the event concludes. And obviously, if your connection's lost, it's the usual procedure, just reconnect using the original link. I'll make the more formal introductions now. So first of all, just on the topics that we are covering today, I should mention that Tim Bewley KC, who was due to be speaking today on recent High Court litigation on SIL, isn't here because of an urgent hearing, but he is going to be providing that talk as a written document, and that'll come to you all in due course. So apologies if you were desperate to hear about SIL case law, but it will be coming. So the other speakers who are here today include Alex Goodman KC. He was due to speak last week, but is now going to be speaking today at this webinar. And I'll begin by introducing Alex. Alex has lots of experience in planning and environmental law. Relevant to today's talk, and he's covering climate change litigation. Alex is currently acting in a claim challenging the Gatwick Second Runway DCO, and he recently acted in the Court of Appeal in the Rights Community Action case and for Friends of the Earth and Greenpeace in relation to the protest rights of the Just Stop Oil protesters. We also have speaking today, as I mentioned, Dr. Ashley Bowes. Ashley's Band 1 ranked specialist in all aspects of development and the use of land, and has very recently won the Chambers and Partners Planning Environmental Junior of the Year award. He acts for both developers and public authorities across planning, and he's also on the Attorney General's panel. Ashley, as you may know, is the general editor of Sweet and Maxwell's JPL, the Journal of Planning and Environmental Law, and he's also the author of the OUP textbook, A Practical Approach to Planning Law, and a new edition is just out. So free plug, go buy the book. It is an excellent book. I know lots of people have been looking forward to the new edition of that. We also have speaking today Ben Fullbrook. Ben is a barrister at Landmark Chambers, specialising in planning, environmental and public law. He's ranked as a leading junior in planning and administrative law, regularly appearing in the High Court and Court of Appeal. He's on the Attorney General's B panel, and his clients include a wide range of developers, NGOs, and government bodies. And then in addition today, we have Siân McGibbon. Siân is a specialist in public and environmental law, ranked as a leading and up-and-coming junior in the directories. And I'm currently working with Siân on a very interesting FOIA appeal in relation to the government's legal advice on lockdowns. Thank you. So what we plan to do is we're going to go through the various talks now. As I've said, questions will be dealt with at the end. I won't further interrupt the talks. Each speaker will transition one after the other. And then at the end, we will all reappear on the screen in order to deal with any questions that you've got. So without anything more, I'm going to hand over now to Siân for the first talk.
Thank you very much, James. All right, and I think I'm in control. Good morning, everyone. And it is a good morning because not only is the sun shining, but also what better way to start the week than with an update on the Aarhus cost cases from past year. And I should warn you at the outset, this is kind of going to be a story of two halves for the Aarhus Convention. We start with some sterner words from the Court of Appeal, and then I'll move on to leave you with some lighter notes from the High Court before I hand back to James for the practice and procedure case law update. And then, as he says, there'll be a chance at the end to ask all your burning questions and share your thoughts once we've heard from the rest of the speakers. A risk of being predictable. Where else to start but with, next slide please, but with Treasury versus global feedback. The only show in town really this year in terms of Aarhus costs cases. This was a judicial review brought by Global Feedback Limited against the Treasury and BEIS, which challenged a decision to make regulations which gave effect to the free trade agreement with Australia. And the argument essentially was that that would lead to increased beef imports from Australia and thereby to increased carbon emissions. And in the High Court, Mrs. Justice Lang had found that the case did fall within the scope of the convention and should benefit from Aarhus protection. So it was the Treasury and BIS which appealed to the Court of Appeal, and drumroll, succeeded. The key principles from the Court of Appeal were that the court should not look simply at whether the claim or the ground of challenge was broadly to do with protection of the environment, or whether the effect of the decision or legal provision had some bearing on the environment. But, and I've put the quote on the slide because it's a pretty important one, in a nutshell, what matters is whether the purpose of the national law that has allegedly been contravened is to protect or regulate the environment, not whether the decision being challenged has an effect on or some connection with the environment. And in this case, the provision in question, the power under which the regulations was made, was not designed to protect or regulate the environment, and so the entire claim was outside the scope of Aarhus protection. So not the result we had expected, and kind of perhaps overturned some strands of the conventional understanding of the scope of Aarhus protection, and we'll come later on in this talk to applications of that by the High Court, but it's caused something of a flurry, as I'm sure many of you who work in this area will know. That is not the only trip to the High Court for the Aarhus Convention in the last year. We also have the case of Crown versus Hallam and others, featuring our own Alex Goodman KC, who will be speaking shortly. The key takeaway from this is that the Aarhus Convention rights are not a relevant consideration in sentencing for environmental protesters. So in this case, the appellants who were appealing against their sentence, they were protesters from Just Stop Oil, argued that the Aarhus Convention should be an aid to interpreting convention rights, and so should be taken into account when sentencing for offences that had been committed in the course of environmental protest or protest for conscientious reasons. The Court of Appeal found that the appellants were not penalised for exercising their rights in conformity with the provisions of the convention, but for criminal offences in the usual sense. And there are two key reasons for the conclusion that they couldn't rely on the Aarhus Convention. Firstly, that it's not directly incorporated into English law, and that was the primary ground for that decision. But also that in any event, Article 3.8 of the Convention did not extend to cover the appellant's activities. And so neither the prosecution nor conviction nor the sentencing was contrary to the Aarhus Convention in that case. And so we have a couple of some food for thought to finish with in terms of these Court of Appeal judgments from the past year. think it's fair to say they've thrown into doubt some of the cases from 2024, which I believe you heard about during this session last year. The first of those being Shell versus Persons Unknown, in which the High Court had held that the Aarhus Convention can apply in contempt proceedings, and it perhaps remains to be seen where that stands post Hallam. And having been spoiled for Court of Appeal cases this year, I wonder whether there might be more to come with those. Well, firstly, global feedback, which, as I say, has overturned a lot of what we previously thought we knew about the scope of the Aarhus Convention. I've got a case, for example, coming up in January next year, which is about farming subsidies, and the government's now challenging whether they are or are not within the scope of the Aarhus Convention, and I expect that will be one of many kind of challenges that come in the wake of global feedback over the course of next year. And we may also find that Shell is not the last word on contempt proceedings in the wake of the judgment in Hallam. I promised today that this would be a story of two halves, and I have some cases from the High Court which post-date global feedback and perhaps lighten the mood a little for Aarhus lovers in the audience. The first of those, we have Green Lane Association versus Central Bedfordshire Council. And as I say in the slide, the short answer is that this is an application of global feedback by the High Court, which perhaps gives a bit of hope for those looking to rely on the Aarhus Convention moving forwards. So this was a judicial review of an experimental traffic regulation order, and the council applied in reliance on global feedback, arguing that the case didn't fall within the scope of the Aarhus Convention. And another feature which will be important is that they applied after having accepted in their acknowledgement of service that the Aarhus Convention did apply. They sought to argue that it didn't fall within the scope of protection, and alternatively that the cost cap should be increased to £35,000 in that case. Deputy High Court Judge Karen Ridge was not having this and held that the relevant provisions read as a whole did have the aim of protection and regulation of the environment, applying that test from the Court of Appeal in global feedback. And the particularly reassuring feature of this judgment, I think, is the thoroughness with which she looks at the legislation as a whole, the wording of the provisions read in their entirety, and also the aims of that legislation, which she found were linked to protection of the environment in a broad sense, particularly to the protection of public amenity. She also held that the late application meant that the local authority was subject to the test for relief from sanctions. And so even though it had been made relatively early in the proceedings, applying Denton, the lack of prejudice to the claimant, or relative lack of prejudice, given that it was made relatively early on in the lifetime of the claim, wasn't material, and it wasn't enough to get over the Denton line. And that again will be some reassurance for anyone acting for a claimant where you have Aarhus cost protection, but there might be otherwise have been a question mark around that in light of global feedback. It suggests the court will not be open to reopening those questions in light of the Court of Appeal decision. And then finally, not quite time for James yet, we have the Badger Trust versus Natural England. Now this is a delightful judgment typically delightful judgment from Mr. Justice Fordham. It's an interesting one. The Badger Trust sought judicial review of licenses which had been granted by Natural England for culling of badgers in various farming areas. And Natural England sought to vary the Rule 26 caps so that the cap against wild justice, one of the claimants, would be 20,000 and against the Badger Trust, 30,000. And they cited various features of the litigation in support of that application, one of which being the fact that the proposed caps were said to be proportionate to what Natural England could recover if it successfully defended the claim. But they relied on the burdens for a public authority like Natural England in having to defend litigation of this type, which was said to produce detrimental real-world deficits. And that was particularly said to be so in the context that Natural England said the claim had limited prospects of success. It wasn't a strong one, despite the fact that it had been granted permission by this stage. And also what Natural England said were the limited implications of the claim for the environment. It was also said that Wild Justice and the Badger Trust had been able to make budgeted provisions for the £10,000 cap each towards Natural England's costs, plus their own lawyers' fees, which were also nearly £60,000 budgeted, and court fees of a further £1,000. And so it was said that in practical terms, in real world terms, Wild Justice and the Badger Trust had chosen to pitch for a certain level of crowdfunding, and could have pushed for more and still did have the ability to go and pitch for more. And so there was a lot of reliance on detailed inspection of the financial information that had been put forward by the two charities, and to support the suggestion that the increased caps would have been real-world affordable, as Natural England put it. Now, it's fair to say that Mr. Justice Fordham gave that short shrift. He was not happy with the wider approach of subjecting charities or claimants' finances to this very intricate level of inspection. And he was also unhappy with the wider principle that the default caps should be lightly departed from. So he emphasised firstly the function of the default caps as providing a principled starting point for the court, even where there is an application to vary the caps. Secondly, the chilling effect of the court departing from those default caps and doing so regularly or lightly in terms of deterring claimants from bringing environmental challenges. And thirdly, the undesirability of having satellite litigation in Aarhus cases, and that's perhaps all the more so in the context where we're going to be getting some of that as a result of the global feedback judgment. And so for all these reasons, Fordham was quite stern in his judgment, I think it's fair to say, in terms of discouraging applications to vary the caps, and spoke quite strongly in favour of the justification for those defaults and the strength of the reason needed to in an application to vary them. That's the lowdown on Aarhus in the last year. I think a couple of the other speakers will be touching briefly on some of the other niche aspects, but I will hand back to James for practice and procedure and look forward to your questions at the end of the session. Thank you very much.
Thank you, Siân. Let's make sure I've got control of the slides. So I'm moving on to deal with other aspects of practice and procedure from the last year, obviously excluding Aarhus costs. There are six main topics I'm going to cover. So first of all, permission issues, so permission to apply for judicial review issues. Secondly, delays and extensions of time. Thirdly, and this has become a perennial favourite in practice and procedure in public law, filing and service failures. Fourthly, a sort of roundup of costs outside of Aarhus over the last year. Fifthly, I'm going to look at interim relief. And then sixth, cases on transfer, regional transfer on the whole. And then finally, having done those six main topics, I'm going to come back and look at a handful of other practice and procedure issues that have arisen over the last year. So it's been a really big year for cases about permission. And there are four that I want to consider. First of all, Ramdas, which is a Privy Council case on what the test for permission to apply for judicial review is. Secondly, Al-Haq, which is a decision of Mr. Justice Chamberlain about when a rolled-up hearing should be ordered. And as you'll know, rolled-up hearings are common in planning JRs. And then Amori, which is about the ability of a court to determine preliminary issues at the permission stage and make them appealable. And then fourthly, the case of BC and Surrey about the ability to appeal extension of time decisions when they're made at the permission stage. So I start with Ramdas, which is an important case. It's a Privy Council decision on appeal from Trinidad and Tobago, but you can see from the judges who determined it that we have a number of sort of leading public law Supreme Court justices deciding the case. And what we take from it is, first of all, an emphasis again that the judicial review permission threshold is a low one. It's there to ensure that the claim is not weak or vexatious, to ensure there's no discretionary bar or knockout blow. But if there's a realistic prospect of success, permission should be granted. And if it's going to take the judge a very long time, rather than being able to do this on a quick perusal to determine the matter, then ordinarily permission would be granted. And the Privy Council also emphasised that while the public interest in a particular question is a matter that is relevant to whether you grant permission, it's unlikely that in and of itself that is going to be the determinative factor. One is still looking for a claim with a realistic prospect of success. So I think a helpful case if you're trying to seek permission on emphasising the low nature of the test for permission. I then turn to the case of Amori. Now, this was related to the Palestine Action litigation, so very far away from planning. But it raises an interesting issue, which is, of course, that there is no ability to appeal, if you're the defendant, the grant of permission once it's been granted, unless in a very unusual case you hadn't been served prior to permission being granted, which I think these days is a very rare occurrence. So the fundamental issue is, what do you do then if there is some key point that falls to be determined at the permission stage, and which, if it goes against the defendant in the High Court, they would have no ability to reopen that at the substantive hearing or to challenge it by way of appeal. And what Mr. Justice Chamberlain said, and he referred to an earlier case where the same thing had happened, is that what the court should do in that situation is determine a preliminary issue at the permission stage and formally determine it as a preliminary issue. And in doing so, you make that decision on the preliminary issue itself appealable, unlike the grant of permission. So in that case, the issue was alternative remedy. And in relation to alternative remedy, the court made a finding on that matter as a preliminary issue, therefore allowing the matter to go as it did on appeal to the Court of Appeal. Now, I'll come in a moment to another aspect of permission, which is appealable by a defendant. But before I do that, I want to just consider Al-Haq, which is a case, again, not in the planning context, but where Mr. Justice Chamberlain, again, lead judge of the administrative court, gave guidance on the considerations that the court should take into account in deciding whether to order a rolled up hearing. And as I said earlier, these are a pretty common occurrence, really, in sort of large scale planning challenges. So the court emphasised four things. First of all, the court needs to look at the importance of the matter being determined quickly. The court said, well, look, JRs are determined relatively quickly, even where there aren't directions for expedition. But if there's a reason why it needs to all be determined very much more quickly, then it's possible that you might want to look at a rolled up hearing. Then secondly, the question that has to be asked is, would a rolled up hearing likely result in a final decision more quickly than a separate permission stage? And the court said, you know, ordinarily, decisions on the papers can be made relatively quickly and a permission hearing listed relatively quickly thereafter. That might be slightly optimistic, but that's the idea. And by contrast, a rolled up hearing could take a rather longer to go through the procedures for and get listed. Of course, what the judge then said was that if there's a prospect that permission may be refused on all grounds, then a separate permission stage might actually mean you get a quicker outcome overall than if you go for the rolled up hearing. But if you take the view at a relatively early stage that the claim or some part of it is going to get permission, then it's probably, and there is a need for urgency, then you're probably better off going for the rolled up hearing. And of course, the judge mentions that the worst case scenario is where a claimant gets some grounds granted permission, but not others, and then seeks to appeal or renew in relation to those grounds they didn't get permission on, and that can slow things up. And in that situation, actually, once one ground is held to be arguable, you might as well look at a rolled up hearing rather than refusing permission on a particular ground and setting this off for a slower route to determination. Then one has to ask the question, would the rolled up hearing last substantially longer than permission hearing? And of course, ordinarily that would be the case because permission hearings ordinarily should only be 30 minutes or perhaps an hour, whereas a rolled up hearing is going to be much longer. But the judge pointed out that there are more complex cases where the permission stage and the oral permission stage can be listed for a day or more. And if that's the case, then frankly, one might as well look at the rolled up hearing because the time that's going to be taken is so considerable at the permission stage. And then one also has to consider how much more of a burden a rolled up hearing puts on the defendant. That is a relevant consideration, albeit that the difference between the two, depending on circumstances, may not be pronounced. So if you are looking at a rolled up hearing going forward in a planning case, albeit this wasn't a planning case, you will need to really start with Mr. Justice Chamberlain's guidance in this case. Finally, on the permission cases for this year, I want to talk about BC. This again was not a planning case, but a housing case. There was a rolled up hearing in the course of which the judge both extended time for bringing the judicial review, granted permission, and allowed the claim. And the issue that the Court of Appeal was faced with was, is the issue about whether to extend time one that can actually be appealed? And the claimant, perhaps somewhat ambitiously, argued that you couldn't reopen that question on appeal because of the effect of CPR 54.13. Now, the court, in granting permission for this appeal to be heard, said if that was correct, then the well-known planning case on delay of Gerber and Wiltshire would be incorrectly decided, as indeed I think would be the Thornton Hotel case. The Court of Appeal rejected the idea that 54.13 could block an appeal in relation to an extension of time. They said that wasn't a bar, and if one was looking for the interaction between the rules to be explained, you needed to go to Lord Justice Stanley Burton's judgment in the MD case. What was also of relevance in this case was that there was an argument made about the extent to which the court would look to interfere with the decision of a judge that had been made to extend time, because obviously it has an element of discretion. And the court made clear that it will not interfere unless the judge has made a misdirection of law, failed to have regard to relevant considerations, or the conclusion is clearly wrong, i.e. there is a higher threshold for challenging an extension of time because it is a discretionary decision. So I turn then to the issue of delay, and there are 5 cases I want to look at for these purposes. Hynot is an interesting case. It was a consent granted under some very bespoke regulations for geological gas storage sites. And the important point is that the consents were neither under the planning, the Town and Country Planning Act, nor the Planning Act 2008. So the strict 6-week time limit that applies in the rules didn't apply to this case. It was a JR that had to be brought promptly or in any event within 3 months. And the claim was brought right at the end of the 3-month to the day period of the decision being made. Now, there was a very interesting debate in the case about when the decision ran from, because the decision was taken on the 17th of March by the Secretary of State, but no one was told about that decision. It wasn't published because under this particular regime, the North Sea Transition Authority had to also make a decision before the matter would become operative. So that decision was made following the Secretary of State's decision, and then they were published together over a month later in April 25. And the court had to consider, does time run from the making of the decision or the publication of the decision? And the answer is it runs from the making of the decision, even though the decision wasn't published. But the fact that you didn't know about the decision would be relevant to the question of promptness. It would also, of course, be relevant to the issue of extension of time. And then what's, I think, really interesting about the case is that what we get from the court is a re-emphasis of the importance where the 3-month and promptness time limit applies, that you can't just wait, as we all know, to the end of the 3 months. You must act promptly. And what's emphasised is that if you're talking about major infrastructure, even if it is not under the 2008 Act, you have an obligation to act particularly promptly. And indeed, even though you have technically got 3 months, you will very rarely be found to be prompt if you've brought it more than 6 weeks from the decision being made, because the 2008 Act time limit is effectively relevant by analogy. One other interesting point was, remember Uniplex, the case that said that the promptness requirement was potentially contrary to EU law. It's of course why we changed our CPR rules in judicial review in planning to have a strict 6-week time limit rather than a requirement for 3 months or promptly. The idea was that promptness was uncertain, it wasn't compliant with EU law. Well, Uniplex, not relevant anymore to Town and Country Planning Act cases or Planning Act 2008 cases, but relevant to other consents within the development sphere. Uniplex is dead. It no longer applies, according to the High Court, because of the withdrawal from the European Union. I then turn to amalgamated smart metering. This was a judicial review of a planning permission. The question that arose in this particular case was how one deals with the jurisdictional issues that you might want to raise. So obviously, if a claim is filed or indeed served, as we'll come to, out of time, the court has no jurisdiction. And alleging no jurisdiction is something that CPR Part 11 specifically deals with. And CPR Part 11 does apply to judicial review. So the question was, are you required, if you think the claim's been lodged out of time, or even filed out of time, as we'll come to in a moment, do you have to use the procedure in CPR Part 11? And the court said, well, no, you don't, because the court through the permission stage is its own gatekeeper. And so it's perfectly well open to you in a delay case where you say the claim's been brought outside the 6-week time limit for planning JRs, to simply raise that in your summary grounds. You don't have to make a specific application under CPR Part 11. I return to the BC case, which we spoke about earlier in relation to permission issues. Return to it again simply on the question of delay. Again, in that case, the court gave very strong emphasis for the need for judicial reviews to be brought promptly. And I think what's particularly interesting is that we see at paragraph 18, the Court of Appeal trying or perhaps suggesting that they are going to be looking at pulling the Good Law Project case law with very strict procedural rules on time and service, etc., into the question of delay in judicial review, saying it makes salutary reading for those who need to comply with the short time limits imposed in judicial review cases. Now, I'm not sure that's a happy turn for the law, for the Court of Appeal to be dragging that Good Law Project case law further in to questions of delay, but that's what was said. And then Wallace, this was planning permission, two planning permissions, one granted in 2021 and one granted in 2022. The JR is lodged in April 2024. Why? Well, the council made an error because they didn't actually notify certain residents that they should have done. Now, on the face of it, that of course would be a good reason to extend time, and it's happened in other cases. But here, the claimant made a fatal mistake because having found out about it, they still delayed. They waited over 3 months before they lodged the claim, and that was fatal. And then finally on delay, Khan, one of those cases falling between section 288 and 289, but essentially the appeal was filed late, and the court were not prepared to extend time. I mean, I guess it's just a further emphasis of the need to get your claims in on time. And obviously you've got that terrible 28-day time limit for enforcement appeals. So service and filing issues. Start with this case, Rogers, which is probably now the leading case on what happens when you fail to serve in time, and the High Court had agreed to extend the time for service in a statutory planning review. The Court of Appeal overturned it, emphasised again, if you fail to serve within 6 weeks, as you're required to in a planning statutory review, you're going to have to show you've taken all reasonable steps to comply within the time limit and to show that you've made your application to extend the time for service promptly. And the Court of Appeal, taking the very strict view that's been taken by a number of courts now, said the High Court had been wrong to extend the time for service in that case. One then sees a similar sort of series of themes in the Hurstmonceau Museum case. Again, this case fell on the boundary between section 288 and 289. But again, the failure to serve the proceedings was fatal because they had not met the strict test of taking all reasonable steps to comply within the time, and also they hadn't acted promptly in making the application for an extension of time. Those two hurdles extremely severely applied, as we'll see across all of these cases. And then I just deal with a handful of other issues around service. These are on the whole not planning cases. So Halen was a JR in relation to a student's JR against a university. Again, the claim form had not been validly served. End of story. And Scott and Haringey, an attempt was made to serve a non-signed, non-sealed claim, and then to apply for an extension of time failed. So I think the lesson, I think you all know it by now, although it clearly is still causing problems. If it's a judicial review, you have to serve the claim form within 7 days of issue. But if it's a statutory planning review, you've got to file and serve within 6 weeks. And if you don't do that, you are most likely not going to get an extension. The test of having done everything you reasonably could to serve within the time is not very easily satisfied if you have failed to do it. And moreover, if you're going to have to make an application for extension of time, you better get on with it. Now, as I've said before, my view is that there are very strong reasons why this very strict approach should not apply to planning statutory reviews where you have to file and serve within 6 weeks. And those arguments were articulated in the Farnham case, but rejected by the courts. I still think one day those arguments will prevail because the position is unduly harsh. Now, I don't have time to cover this one, but this is an interesting case because it concerns a judicial review that was filed under the electronic filing pilot scheme, where certain information that the court required was not provided, and so everything had to be refiled, and the court refused to backdate filing date. And the court said, in future, if you're using this process, backdating of filing date is not going to be easily achieved, and it has to be an application made on notice to the other parties. So I turn to some other topics. First of all, costs outside of Aarhus. First of all, I think I need to mention CPR 44.6. That's been added to say that the judge who carries out the summary assessment need not be the same judge who heard the application or trial, overturning a case that held to the contrary in the JR context, the ISA and Home Department case. And then I think New Lottery and Gambling Commission deserves a mention. It's not a judicial review, but it's one of those other types of proceedings, and there aren't many of them, that have interested parties in them. So it's only JR and a few other very bespoke sets of proceedings that have this concept of interested party rather than just claimants and defendants. And what the court ruled here was that CPR Part 25 only allowed a security for costs application by a defendant, not by an interested party, but that there might be nonetheless a jurisdiction more generally for an interested party to apply for security for costs under CPR 3.12p, but not any way that would allow the circumvention of CPR Part 25. And then just a reminder in the IX case that the M and Croydon rule, well, there you are, I've made the mistake already. M and Croydon, which sort of deals with when you might be entitled to your costs where a JR settles, those guidelines should be seen as that, guidelines. They're not general cost rules. They should not be followed slavishly, and therefore don't expect that a court must follow those guidelines in every case. Costs are discretionary in all cases. I then turn to interim relief. I'm going to cover principally the first two cases I mentioned here, POMP, and secondly, Nobel. The first one was a quite ambitious application for an interim injunction, but does contain a useful reminder of the principles that apply to interim relief in public law. And the second one answered a much more specific question. Is a cross undertaking needed when the interim relief that you're seeking is a stay, not an injunction? And also, what is the position where losses are self-inflicted by the party who wants the benefit of the cross undertaking? I've mentioned a couple of other cases there that I'm not going to deal with today, but those are probably the other pretty important interim relief cases that we've seen in the planning public law context more generally. So just talking about the tests for interim relief, I mean, here, the claimant sought the continuation of an interim injunction prohibiting the Secretary of State from signing off an agreement with a foreign government in respect of the Chagos Islands. Now, one might think that was quite ambitious, but what is helpful is that Mr. Justice Chamberlain emphasised that when applying the balance of convenience test for the grant of interim injunction, it is important to bear in mind the public law context and whether the public interest would or would not be served by the grant of interim relief. And also emphasised that it's extremely important for interim relief applications to be made quickly, and the 2-month delay in seeking interim relief here was fatal. Moreover, the court said that the particular type of injunction sought here to stop the UK government negotiating a treaty under prerogative powers would directly cut across established principles of public law, as one would not be surprised to hear. So that failed. And then stays and cross undertakings, the Nobel case. Here, there were judicial review proceedings on foot against the North Sea Transition Authority in relation to advice that it had given to the Secretary of State. And in those judicial review proceedings, claimants sought a stay to prevent the Secretary of State proceeding to make his decision, having received the advice of the NSTA, which advice was alleged to be unlawful in the ongoing judicial review. And there were two questions. I mean, the first one was, did the court have jurisdiction to grant stay when the decision that was being challenged was not the decision of the Secretary of State that was being sought to be stayed, but the decision of the NSTA at an earlier stage to give advice. And the court held there was indeed jurisdiction in that circumstance to grant a stay, re-emphasising that a stay is a remedy that's open to a claimant to seek in a planning context to prevent implementation of planning permission. And that was the point made by reference to what said Obiter about that in the Ashworth Hospital Authority case. Secondly, the court ruled that, and there was very much a lack of clarity on this point prior to this decision, were cross undertakings required in damages where one is seeking a stay rather than an injunction? And the answer is yes, if the stay is in effect operating very much like an injunction, i.e. to stop a third party doing something. And if the losses that may be caused by the injunction are self-inflicted, that's relevant to whether cross-undertaking is required, but not a decisive consideration. And then transfer. So, as you know, you are required to commence your claim for judicial review in the court which has the closest connection to the claim, not where it's most convenient for the claimant or claimant's representatives or the defendant or their representatives, but where the claim is most closely connected to. And there is a jurisdiction available to the court to transfer cases between the regions where they've not been started in the region that they're most closely connected to. Now, this regime used to be operated by Mr. Justice Fordham, and I think one struggles to find a decision where he ever excused people commencing their claims other than in the court to the closest connection of the claim. The matters now seems to have moved over to Mr. Justice Hill because all the decisions are from him this year. And although the majority of them still result in transfer to the court of closest connection, it seems he has adopted a slightly more flexible approach, and there are some examples of him allowing claims to proceed in venues that are not the closest connection because of issues around costs and legal representation. So I finish with just a roundup of other procedural matters that may be relevant. There's some guidance generally applicable to all JR on media access to skeletons by Mr. Justice Fordham in the Metropolitan Police Commissioner case. There's another case on notification of the Speaker where issues of parliamentary privilege arise. And just beware if you do have those issues. My own personal view is that the Speaker is a bit of a menace at the moment in relation to this, and is intervening very strictly and fully in cases, and effectively sort of shouting heresy the moment anyone tries to refer to anything that's ever happened in Parliament in its entire history, which does seem a little bit excessive, but that's where we are. Then the Powell case raises really a very old issue that's still not been resolved by the Rules Committee. And that is that if you're bringing a statutory planning review, is a very fixed number of people who are the defendant. in those proceedings, or respondent in those proceedings, namely the Secretary of State, the local planning authority, and any other person having an interest in the land to which the proceedings relate. There is no interested party concept in planning statutory reviews, either in 288 or 289. But there is a power often used to allow those additional people who don't meet the categories to join, often as additional defendants. But this constantly causes confusion and difficulty. And frankly, the rules just need changing to make there a clearer status for those who are affected by these decisions but don't meet the strict criteria. And then I should mention finally the Greenpeace case in Scotland. This is a Scottish case dealing with the fallout from the Finch judgment. The question was, what is the appropriate remedy to certain grants of consent given in Scotland? Which grants of consent it was accepted by this point because of the Finch case were unlawful, having regard to the fact they hadn't assessed the downstream emissions. And the question was, should the decisions be reduced, quashed in our language, or should there simply be a declaration to allow the projects to proceed? The court concluded that the balance lay very much in quashing, so the decision could be taken again, taking into account those downstream emissions. And there are some interesting sort of general observations about what's relevant and not to relief. The developers trade in aid matters like energy security, impact on the economy and job creation. The court didn't think that those were relevant. The court did think it was relevant that there had been a proceeding at risk by the developers, knowing that the Finch judgment was awaited. And then they did, though, suspend the reduction via a stay in order to allow reconsideration. But the effect of the suspension was just so the developers had options on how to proceed pending the redetermination, but wouldn't allow them to actually produce oil and gas. So they could do preparatory engineering and construction works at risk if they wanted to, but they were not allowed to actually extract the oil. So that's the roundup on practice and procedure. I'm going to hand over to Ashley.
Thank you very much, James. Good morning, everybody. I'm going to deal with 5 matters. Breaks in use, they're all to do with rights of way and village greens. So first of all, breaks in use, compatibility with use between the landowner's powers and obligations and the public use, concepts of give and take versus displacement, a short point on cost protection and admission of evidence. So the first case is a case brought by the Ramblers Association against first the Secretary of State for Environment, Food and Rural Affairs, but ultimately after she consented to judgment, defended by the landowner Roxlena. And this concerned an application to add various footpaths over a shooting estate, which was hotly contested, and that led to a lengthy inquiry at which the conclusion of which the inspector found that all of the statutory elements to create the footpaths had been satisfied except one, which was that there was a 4-month break in the public use of the ways, and the inspector found that that was sufficient to mean that the public use of the ways had not been actually enjoyed for a full period of 20 years. And just to remind ourselves of the statutory definition that leads to the presumption of dedication under the Highways Act, set out at section 31. There are the 2 statutory terms that were at issue in this case, whether the ways have been actually enjoyed as of right without interruption for a full period of 20 years. That decision was challenged by the Ramblers Association on 2 grounds. Firstly, that the foot and mouth outbreak and the breaks in user that resulted from it were not legally capable of preventing a claim under Section 31 of the Act, and secondly, that the inspector had wrongly applied a de minimis test. That all came before Mrs. Justice Lang, who held that the determination of actual enjoyment is a matter of fact for the inspector to evaluate against the evidence, but that must be done against the applicable legal test. And in considering that question, relevant facts which place the public's conduct in context will be relevant to answering the question of how a reasonable landowner would have viewed the public's use over the relevant 20 years. And therefore, the reason for an intermission in public use of the way, including whether or not the way is available, is likely to be relevant information in deciding whether over a 20-year period the public have asserted a continuous use as of right. The judge rejected the notion that anything more than a de minimis break in public use will automatically break the 20-year chain, but the inspector found that the inspector didn't make that mistake. But what she did find fault with was the inspector's use of a de minimis threshold as a benchmark against which to assess whether the period of non-use was sufficient to break the chain. So it sort of corrupted or distorted her evaluation of the break. And interestingly, the judge went a little bit further than ordinarily they do, and found that it was irrational on those facts, i.e. that even if the inspector had applied the correct test, there was not only a doubt whether she'd have come to the same conclusion, but that no reasonable inspector properly directed could have concluded that the break of 4 months meant that the 20-year period wasn't satisfied on the evidence, which is a particularly striking finding for the administrative court. It presents a few issues, this decision. I mean, the first issue is that the statutory language, as we saw, Section 31, it is very clear. It couldn't be clearer about what the quality of use is that's necessary to satisfy the relevant test to give rise to the presumption that a way has been dedicated as public highway. It needs actual enjoyment for a full period of 20 years. And there's nothing in the wording of either that section or otherwise that suggests that if the use is not actual enjoyment for 20 years, then it can be in some way overlooked if that's explicable. And whilst the judge drew support from cases in the private rights of way field where the courts have accepted an explanation for non-use as being relevant to whether a right was asserted, that is, of course, in a very different context where you have one tenement, one parcel of land, and those entitled to possession of it asserting a right over another parcel of land, rather than the general public asserting a right over a piece of land. And in the case of a private right-of-way, where you've got maybe a very small number of individuals who are asserting the right, it might well be considerably easier as a matter of evidence to discover why the use hasn't been exercised. Whereas when you're dealing with the public at large, it might be very difficult to understand why the public have stopped using a particular way. It might be because of the foot and mouth outbreak, or it might be because the weather was inclement, or because they just don't want to use it and assert a right of way over a person's land anymore. It's more diffuse. And there are cases which the judge identified as suggesting that the law was different. Roxlina number 1, which was a judicial review at an early stage in the rights of way application process for this piece of land, where the judge had said that the question of use was a simply objective one and that the subjective reasons for non-use were not relevant. The judge decided that A, wasn't binding, it was part of the obiter of that judgment, and B, it was wrong, applying the private rights of way case law. And also, perhaps more difficult to distinguish, was a Court of Appeal judgment in de Rothschild, where the public had stopped using a way through a farmyard during the outbreak of the Second World War, where you might understand there'd be pretty clear reasons why the public wouldn't assert a right over a piece of land during wartime, which went through land that was requisitioned by the RAF. So there was a very clear explanation why the public weren't using it. But nevertheless, the Court of Appeal found that that wasn't sufficient to explain the break, and found that the relevant use hadn't been matured into a public right. The Prescription Act 1832, which is the act which deals primarily with private rights of way, has the same wording as the Highways Act 1980, but as I was canvassing a moment ago, has quite different implications. It's one land parcel asserting a right over another land parcel, rather than the general public asserting a right over a piece of land. And of course, the consequences of all of this would mean that a right of way could be acquired over a person's land in circumstances where the public simply chose not to use it for the full 20 years, even though the way might have been physically available, so it wasn't obstructed in some way. And that obviously has quite significant implications for the acquisition of rights of way. And that is why, doubtless, the Court of Appeal granted permission to appeal, and that will be heard in the spring of next year. So turning from rights of way to village greens, just a quick reminder on the concept of village greens. That's a land designation that arises in circumstances where a section of the public have used a piece of land effectively for informal recreation for 20 years without being told they're not allowed to, and without being given permission to use it. And where all of those tests are satisfied, that the land is designated as a village green, with the consequence that the landowner isn't allowed to interfere with the public's rights of recreation, save only as to their pre-existing uses. And they're certainly not allowed to develop the land in any way by erecting buildings or otherwise on it. So it has very significant implications for landowners. This case was unusual in that it involved school playing fields that were possessed by an academy school via a long lease. And academy schools are independent of the local education authority. They're not necessarily fee paying. Not in this case. It was a non-selective state school, but it was independent of the local education authority. The freehold of the land, however, was held by the city council for the purposes of education. So that was all common ground. It was a large area of land. It was 11 hectares, and it was laid out as school playing fields. And the school concluded about 14, 15 years ago that allowing unrestricted public access to its playing fields was incompatible with the safeguarding duties that were starting to emerge, and it wished to regulate the access by the public to the land by fencing it and controlling when the public could go on, which stimulated an application to register the land as a village green. And after a series of public inquiries, ultimately the conclusion was by the inspector that the land did not meet the tests because of signage on the land and objections by the landowner to prior village green applications. But nevertheless, the relevant committee of the council decided to register the land against that advice. The school, as the possessor of the long lease, obviously confronted with a series of consequences arising from that decision. Firstly, that the local inhabitants, so the people within the designated neighbourhood, which had given rise to the registration, gained a property right to use the land at any time for informal recreation. That, so the case law tells us, can expand and vary from the use which gave rise to registration, subject to the only constraint that the landowner is allowed to continue to use their land as they did before. However, it is not lawful to obstruct access to the land or erect buildings on it otherwise than for the better enjoyment of local inhabitants. So it, for example, wasn't possible for the school to fence the land and control when members of the public accessed it. So confronted with that, it chose one of two potential routes available to it. It could have sought a judicial review of the decision to register the land. That, of course, as we know, would be limited to whether the council had made an error of law in registering the land. It's not a review of the merits. Or it could have brought a claim under Section 14 of the Commons Registration Act, which is a full merits review by the High Court of the decision to register the land. And that's the option which it chose. it's not confined, importantly, to simply the legality of the decision taken by the City Council. Unlike judicial review, it is a wide-ranging review on the merits, hearing primary evidence and making findings of fact on that evidence. So just to remind ourselves of the statutory test that was at play here, what needed to be demonstrated for it to be a village green was that a significant number of the inhabitants of any locality or neighbourhood within a locality indulged as of right, that means without permission, without being told not to, and without doing it in secret, in lawful sports and pastimes on the land for a period of at least 20 years. The school brought a claim on a series of grounds. The primary ones were that Section 15, so that section which allowed a person to apply to register land, was not available in these circumstances because registration would be incompatible with the statutory purposes for which the land was held. Secondly, that the use of the land was not as of right because of prohibitory signage that had been on the land. Third, that the objection by the landowner and the school to a previous village green application rendered the subsequent use not as of right, i.e. not non-contentious. And finally, that the use of the land was interrupted by the school's prior use of the playing fields, such that the use was contentious over the 20 years. So turning to the first issue, the judge, His Honour Judge Matthews, sitting in Bristol, held that the Section 15 of the Commons Act 2006, which allows a person to apply to register land, is not available where the land is held for statutory purposes which are incompatible with the village green rights vested in the local inhabitants, which arise on registration. And that was the upshot of a line of authority from the Supreme Court in New Haven and the Lancashire and Surrey cases. In this case, there was no dispute that the freehold reversion of the land was held by the council for statutory educational purposes. The controversial issue was whether the fact that the land was possessed by the school on a long lease, 125-year lease, the school being an academy school, so a private institution independent of the educational authority, whether that meant that the doctrine of statutory incompatibility didn't apply. And the judge, having heard that, dismissed that and found that the land was still held by somebody for the carrying out of statutory educational purposes. So the school was, albeit independent of the local authority, and it was, in that sense, not a public authority, but it was nevertheless carrying out statutory education purposes. But alternatively, the judge held that even though the school itself had no statutory duties on it, the school did have a contractual obligation with the Secretary of State for Education to provide education services on the land, and therefore, in that sense, there was a sufficient nexus between the Secretary of State, who obviously did have powers and duties under the education legislation, and the land by virtue of the school who was possessing it and discharging those duties on the land. So for all those reasons, the judge found that Section 15 was not available. That would have been perfectly sufficient to dispose of the claim and to order that the land be deregistered. But the judge continued to find that the use of the land for educational purposes with the public was inconsistent, because he found that it would prevent physical education of children in compliance with the law, and it would prevent the use of the land for other educational purposes, including the construction of new premises. So the fact that the land could have been used for some educational purposes wasn't the relevant question. The issue was that there would be educational purposes that could not be carried out because of safeguarding or other restrictions if the land continued to be a village green. The implications of that are potentially quite wide, because it means that the incompatibility doctrine applies to land even where the public body subject to the duties, in this case Bristol City Council, is not in itself in possession of the land. And that might mean that the doctrine applies where the body that has the duties, the public law duties, has a mere interest in the land as opposed to a legal estate, so an easement or a profit, for example. Indeed, it means that the doctrine could bite where nobody with no legal duties holds an interest in the land, but as long as a body with duties had sufficient control of the land through, for example, a company which possessed it or controlled it, that would be sufficient. It also has implications for the rights of way world by operation of Section 31(8) of the Highways Act 1980, which prohibits or says that the common law rule around the acquisition of rights not being possible where the person who was in possession of the land didn't have the capacity to dedicate the land, that is preserved by Section 31(8), and therefore this finding will have transitional implications for the rights of way decisions. On the other grounds, which are obviously more fact sensitive to that case, the judge effectively found that the signs on the land were sufficient to render the use contentious, and that previous objections to a prior Village Green application was again sufficient on its own to render subsequent use of the land contentious. Ground 4 is particularly interesting because that explores the difference between give and take and displacement. Give and take, not precluding the public being able to acquire a right. Displacement very much does preclude the public from acquiring a right. Here, what was the issue was that the land had been laid out as playing fields and used as playing fields, and therefore members of the public were excluded from at least those areas of land during the playing of football, cricket, athletics, and the judge found that that was all quite different to the golfers in the Lewis case. It was a Supreme Court decision about 10 or 12 years ago, which where the Supreme Court found that members of the public who'd paused their recreational use whilst golfers played their shot and then carried on enjoying the land for recreation, that wasn't sufficient to mean their use wasn't continuous. And in TW Logistics, the judge found that was all quite different again, because that was an operational port where members of the public had stopped or paused whilst a forklift truck or a lorry or something had gone past pursuant to the port operator's use of the land, and that was all within the sort of ambit of give and take between landowner and members of the public. Here, however, these were large-scale exclusions of the public from sections of land which crossed into the field of displacement. Interestingly, the Court of Appeal dealt with this quite quickly in the record time, under a month or so after permission was sought. It found that the statutory incompatibility question was an interesting one and might have merited granting permission, but due to the other judges' findings, the appeal did not stand a realistic prospect of success and refused permission. A short point on costs, probably unlikely to arise in very many cases, but the school, Cottam School, did seek Aarhus cost protection, arguing that Section 14 of the Commons Registration Act 1965 was covered by the provisions of the Aarhus Convention because it was a review under statute. But the judge rejected that, finding that review under statute was confined to administrative review of the decision below in the nature of a judicial review or a Section 288 under the Town and Country Planning Act. Rather, a Section 14 claim is in the nature of a rehearing de novo on the merits, and that took it outside of the scope of a review under statute under the Convention. The judge rejected the alternative submission that nevertheless the court in its inherent jurisdiction should grant a protective costs order, arguing that, finding rather that the effect of the Court of Appeal decision in Venn is that where a particular claim has been excluded from the bespoke regime, it's inappropriate for the court to exercise its powers, its inherent jurisdiction to cover it. It was rather, however, a Pyrrhic victory for the second defendant, who was the applicant for Village Green status and the person who had contested whether Aarhus cost protection applied, because following the judge's decision, the claimant and City Council enter into an agreement not to recover more than the Aarhus costs against each other. But given the claimant succeeded, it was entitled to recover the remainder of its costs from the second defendant, which did total several hundreds of thousands of pounds. So a lesson in litigation strategy, perhaps. And then finally, an interesting decision about admissibility. Obviously, the barrister inspector who had heard the evidence had produced a very detailed report recording the evidence that he'd heard by members of the public who had used the land, and also his impressions on that evidence, his findings of fact, having heard that evidence tested under cross-examination. The judge, however, found that the inspector's record of the evidence was admissible under the second-hand hearsay rules, but the inspector's findings of fact on that evidence effectively amounted to opinion evidence, which is not admissible in court, save for in the nature of an expert report, which it wasn't being claimed to be. So it was inappropriate to admit what the inspector made of the evidence, but his record of it was admissible. Thank you very much. I'll hand over to Ben.
Great, thank you very much. Thank you very much, Ashley. And I'm going to talk to you now about an often repeated mantra in planning High Court challenges, which is about the weight that decision makers should give to the views of statutory consultees. And there have been some, there's a long line of cases which sort of repeats this same line. There have been some developments in it over the course of the last year or two, and I thought it'd be helpful to just have a think about, well, where are we now? What does this actually mean? What are public authorities required to do, and how will the courts review the decisions that public authorities make about these things? So we'll start with looking at what are statutory consultees, what actually engages this principle, look at what the case law says and how it's developed, and look at what this means in practice and where we currently stand. So why this presentation? As I said, this is a quote from Shadwell Estates and Bretland, which is one of the cases that's recited a number of times by claimants in particular. And it sort of repeats a principle that says a decision maker should give the views of statutory consultees in this context the appropriate nature conservation bodies great or considerable weight. A departure from those views requires cogent and compelling reasons. They are probably familiar words to many of you, and as I said, they're repeated a number of times. But what do they really mean? I suppose the first question you've got to ask is, well, what's a statutory consultee, and in what context is its view going to attract great weight? Now, none of the cases provide a definition of what's meant by statutory consultee, or whether they mean simply a consultee that you have to consult as a result of statutory requirements in the DMPO or otherwise, or whether it's a statutory body that's been established to have particular expertise and comment on particular areas like Natural England in relation to European sites, SSSIs, etc. It is actually unclear. Can't give you a firm answer on that, but it might help to know that the statutory consultee, the term is sort of defined in the PPG. It's where there's a requirement set out in law to consult a specific body, and as you'll know, the DMPO provides a long list of bodies that have to be consulted in certain circumstances where various thresholds are triggered. And some examples are here. I've called them less familiar faces because they don't come up very often, but Canal and River Trust, a Theatres Trust, in certain circumstances, these are bodies that have to be consulted. And in theory, they might therefore engage this principle that a decision maker would have to give great weight to the views of those consultees if they're provided. The more familiar faces are Natural England and Historic England, and these are the ones that account for the majority of times when this principle has been asserted, particularly by claimants. Natural England obviously has a key role to play in relation to appropriate assessment and the habitats regulations. It also has a role to play in relation to Regulation 9 and Article 12 of the directive as far as European protected species are concerned. It can also play a role in landscape issues as well, development affecting national landscapes. It comes up a lot. For the purposes of the habitats regulations, it is obviously given a particular statutory title as being the appropriate nature conservation body for those purposes. Another is Historic England. That has a statutory role providing consultation responses in certain circumstances, and those are set out in the planning listed building and conservation areas regulations, 1990 regulation 5A. You have to consult them where development affects the setting of certain listed buildings, so grade 1, grade 2 star, or it affects the character and appearance of conservation area where the development is above a certain scale. So they come up a lot, and I think there's no question that that principle, in that you'd have to give great weight to the views of statutory consultees, will apply to natural England and historic England, and certainly has generally been found to do so. And let's look now at the case law. And most, I think all of this actually relates to natural England, with the slight exception of Mokes, where historic England was engaged, at least to some extent. So I'm going to run through some of these, run through a bit of the background to them and what the court said about this principle, and then we'll sort of reach a view about where we are now. Acaster, that's one of the cases that's referred to a lot. And so that was a challenge about the White Link, I think Isle of Wight ferry routes and introduction of a larger class of ferry. As you can see, that was challenged. And what happened in that case was Natural England expressed a view, concern about the new type of ferry that was going to be introduced. It said it cannot be ascertained that the introduction of the W-class ferries will not have an adverse effect on the protected European site. The second defendant, I think, was the Statutory Harbour Authority, had obtained some conflicting expert advice that said, conflicted with what Natural England had said. What did the High Court say about how Natural England's view should be treated? O&J said, the fact that Natural England had given contrary advice does not of itself render the decision of Wednesbury unreasonable. In making its appropriate assessment, White Link was not obliged to follow the advice given by Natural England. Its duty was to have regard to it. But given Natural England's role as the appropriate national conservation body, White Link was, in my judgment, bound to accord considerable weight to its advice, and there had to be cogent and compelling reasons for departing from it. So I think I've underlined there the word bound to accord, because it does raise an interesting question. Generally, the weight that a public authority gives to a material consideration and to advice is a matter for its judgment, subject to Wednesbury review. But here, the court seems to be saying that there's an obligation on the public authority to give considerable weight to the views of Natural England. But it's important to note the context when this is happening. This is when Natural England is giving advice well within its remit as the appropriate nature conservation body in relation to the habitats regulations. And then there's a second the corollary to that, which is that if you're going to depart from it, you have to have cogent and compelling reasons. And there have been a few cases recently about what that means, which I'll come on to. So that's Acaster. Morge is another case that's regularly cited. That's partly because it's a Supreme Court case, Supreme Court judgment as well. It was about permission being granted for a bus route. And one of the main issues in Morge was about the impact on European protected species. Natural England had initially objected, but then withdrew their objection to those impacts. And the appeal was dismissed by 4 out of the 5 Supreme Court justices. And Baroness Hale's, part of Baroness Hale's speech at paragraph 45 is again regularly cited, so it's worth quoting. The planning authority were entitled to draw the conclusion that, having been initially concerned but having withdrawn their objection, Natural England were content that the requirements of the regulations and thus the directive were being complied with. Indeed, it seems to me that if any complaint were to be made on this score, it should have been addressed to Natural England rather than to the planning authority. They were the people with the expertise to assess the meaning of the updated BAT survey and whether it did indeed meet the requirements of the directive. The planning authority could perhaps have reached a different conclusion from Natural England, but they were not required to make their own independent assessment. So again, really the suggestion that one defers to the views of Natural England unless you've got a good reason not to. I just sound a note of caution about the Morge case, because that's a case about Article 12 and Regulation 9 to do with European protected species. Now, that's quite a different regime from the appropriate assessment regime. That's where it's generally established that local authorities don't have to decide for themselves whether a license would be granted for works that would have an effect on European protected species or their habitats. Natural England is the licensing body for those things, and those applications would need to be made in the event a planning application is granted. So the actual role that the local authority or the competent authority has in those decisions is much reduced. And so it's much more likely that they would defer to Natural England. One would presume that if Natural England said we've got no problem, then there's not going to be a problem because they are the licensing authority. It is slightly different with appropriate assessment, where the permitting authority, if you like, is the local planning authority. It is the one that has to make the ultimate decision. So it cannot perhaps delegate its decision-making to Natural England to the same extent. It has to give appropriate weight to Natural England's views, but it also has to reach its own conclusion. Prideaux, another case about protected species, about an energy from waste facility. Various ecological concerns were raised. Natural England made initial objections. They were addressed, and then Natural England granted relevant derogation licenses. This is what Lord Justice Lindblom previously, Lindblom J, said about Natural England's role in that process. It said it's clear that the committee gave considerable weight to the conclusions reached by Natural England. That's hardly surprising. It is exactly what one would expect. Natural England is the appropriate nature conservation body under the regulations. Its views on issues relating to nature conservation deserve great weight. An authority may sensibly rely on those views. It is not bound to agree with them, but it would need cogent reasons for departing from them, and then cites a number of the cases that have come before on this issue, including Acaster. Then Smith, that's a case about European sites. Planning authority had granted permission for residential development close to a SSSI. There'd been an appropriate assessment. That was endorsed by Natural England. It was challenged by local residents. And again, Lord Justice Sales, who, as he was at the time, said, moreover, the authorities confirmed that in a context such as this, a relevant competent authority is entitled to place considerable weight on the opinion of Natural England as the expert at national agency with responsibility for oversight of nature conservation, and ought to do so, absent good reason why not. Again, bringing in Morge there, a number of the cases which we've looked at. And that's the position where we were prior to Mr. Justice Holgate's decision in the Sizewell case a couple of years ago, where that formula was repeated regularly, not really interrogated. No one really considered what does that mean. As I said, in Sizewell, Mr. Justice Holgate took a bit of an issue about this constant repetition of what you need cogent and compelling reasons for departing from Natural England. Very simplistically, the background to the claim was that it was a judicial review of the decision to grant development consent order for the nuclear power station. Natural England had expressed some comments about elements of the scheme, and the decision was challenged on a number of grounds, one of which related to the treatment of Natural England's advice. And so what Mr. Justice Holgate said about that was, again, he said, Natural England is the nature conservation body for the purposes of the habitats regulations. In this case, it performed the role of providing specialist advice within its remit to the defendant as the competent authority. There's no dispute that the defendant is entitled to disagree with Natural England, but the claimant complains that when the defendant did so in the present case, he failed to comply with the line of authority which indicates that the decision maker is expected to give significant weight to the views of an expert body, such as Natural England, and to give cogent reasons for disagreeing with their views. I just note there the reference to expert body as opposed to statutory consultee. And again, as I said, it's not quite clear what type of advice actually engages this principle. But Mr. Justice Holgate went on to say, even when disagreeing with expert views of a body such as Natural England, the relevant standard to apply in assessing the adequacy of the reasons is that set out in the South, Save Britain's Heritage in the South Bucks case. And that doesn't include a requirement that the reasons be cogent and compelling. They just need to be intelligible. They need to be adequate. Those principles are well understood. And so he said there's no place for a separate or higher standard of reasoning when one's looking at a decision involving the views of statutory consultees. As I said, he said this, the level of reasoning which the law expects a decision maker disagreeing with the view of an expert body may depend on whether that view is an unreasoned statement or assertion, or a conclusion which is supported by an explanation and or evidence. It may also depend upon the nature of the subject matter. Some advice may not call for reasoning and or supporting evidence. Other advice may do. And this is really, I think, a common sense explanation of the nature of this principle, that it's not all advice from an expert body is going to require a particular degree of reasoning. It might, as Mr. Justice Holgate said at the time, some kind of unreasoned assertion or statement is not going to attract a requirement to give so much reasoning as a detailed and substantiated objection. And it may be that some statements don't require any reasoning at all to be given, and that was the case in Mokes, which was a case where, for development in the national landscape in the Canterbury area, there was quite significant objection from statutory consultees, including Natural England, who maintained their objection throughout the planning process. Nevertheless, the planning authority decided to grant planning permission. In its officer report and other decision-making documents, it didn't specifically engage with the arguments made by Natural England. It didn't, for example, say, we understand that Natural England have said X, but we disagree for Y reasons. It simply stated its reasons for granting the permission, and in doing so largely adopted reasons which were given by the developer. And that was obviously judicially reviewed by the claimant, who was a local resident. That judicial review failed, and one of the grounds of judicial review was that the planning authority had failed to give reasons or give great weight to the views of Natural England. What the Court of Appeal said, effectively endorsing what Mr. Justice Holgate said in Sizewell, was that whilst the views of statutory consultees must be afforded great weight in the decision-making process, there is no heightened standard of reasoning just because a departure from the views expressed by a statutory consultee requires what may have been described as cogent and compelling reasons. That phrase is a form of shorthand for the test in Porter, in which it was said that the reasons for a decision must be intelligible and they must be adequate, and it adds nothing to it. And that was made clear by Holgate J in Sizewell, a passage which Lady Justice Andrews wholeheartedly endorsed in the Mokes case. So that, and then which goes on to say, the reasons for disagreeing with the statutory consultee on the key points in issue may emerge clearly from the reading of the decision as a whole, even if they're not separately identified. The question is whether it's sufficiently clear from the OR that's officer report, why the planning officer takes a view contrary to the views expressed by a statutory consultee, and it's acutely fact sensitive. Some cases may require the principal issues and controversy to be addressed in greater detail than others. In other words, you don't need to specifically identify all of the points, or maybe any of the points made by the statutory consultee. If it's sufficiently clear from your decision why you disagreed with them, that might be argued to be a watering down of that principle. But nevertheless, that's where, on the facts in Mokes, the Court of Appeal ended up. So what does this mean in practice? The law remains and undisturbed that decision makers should apply great or considerable weight to the views of statutory consultees. Mr. Justice Holgate's criticism, and then the Court of Appeal in Mokes' criticism of that sort of principle, didn't really go to the question of weight. It went to the question of the standard of reasons required. But one has to ask, is that correct in all cases? Is it right that in every single case where Natural England says something in relation to the development, you must give that statement great or considerable weight? My view, if pushed, is that can't be right. It seems absurd to apply Mr. Justice Holgate's reasoning in Sizewell just to the question of reasons and not to weight. The two are they're two sides of the same coin. The degree of reasoning is required. That's required is like a quid pro quo for the weight that you've given to the advice. And it is, as I said earlier, well established that the weight one gives to a consideration is a matter for the judgment of a decision maker. I think the position really is that it will be very, very rare that where a statutory or expert body is giving a consultation response in line with its area of expertise, that a decision maker would not give it great or considerable weight. And it may be irrational not to do so in those circumstances. But there might be circumstances where a decision maker could give it less weight, where, for example, it was speaking well outside of its area of expertise, or where it's given a decision or consultation advice that is factually incorrect. They are cases where that general principle might be disapplied. And then in relation to reasons, well, we can be quite clear that any claimant who's now going to the High Court and the Court of Appeal saying, well, there weren't cogent and compelling reasons, isn't going to get very far now. Those reasons will be judged by reference to the well-known South Bucks jurisprudence, and what reason will be required is fact specific. But again, even if there's no direct engagement with the use of statutory consultees, no express engagement, you may not still succeed in a reasons challenge. And by way of concluding thoughts, I think it's helpful just to remind ourselves of what Mr. Justice Holgate said in Sizewell. He said, the present case illustrates the inappropriateness of relying upon statements in the Acaster line of authority as a mantra, rather than looking properly at the materials in any given case in context. So if you're acting for a claimant, it's not going to be enough to simply say, well, just repeat that line and say you didn't do it. You need to go beneath the surface and look at why great weight was required, why the reasonings provided aren't intelligible or adequate to enable you to establish that the great weight was given, or the appropriate weight was given, or the reasons, or what the reasons for disagreeing with that consultation response were. So the final question is, does this really add anything at all to standard rationality and reasons arguments? I think possibly not. It's a helpful line of authority still if you act for a claimant, but on the other hand, I think you do need to go a little bit deeper if you're trying to develop those arguments. And I think that's all. Thank you very much.
Hello, everyone. So I'm going to be talking about climate change litigation, and I'll be taking you through some of the latest cases and well, a bit of the history of all of the cases. So I might just need a bit of help. There we go. Starting with Spurrier, which was the Heathrow litigation in the first instance. And it's useful just to start here because it illustrates that the courts have accepted climate change as a scientifically established phenomenon. The divisional court there in Spurrier recognised that the concentration of greenhouse gases in the Earth's atmosphere is linked to average global temperature, that the concentration of greenhouse gases has been rising steadily, with it mean global temperatures, and that the most abundant of those is CO2, although it's becoming a bigger issue in climate change litigation is non-CO2 gases, which are very difficult to assess, and so have become, for example, in the recent Gatwick second runway examination, were one of the issues. So anyway, the judiciary recognises climate change back in that 2020 case, and there have been quite a few since, which I'm going to run through. Quite a few cases looking at the issue since then. Here's some of the legislation that addresses climate change. The first piece of UK legislation that really got to grips with it was the Planning and Compulsory Purchase Act 2004 as amended, the section 19(1)A, which required the development plan documents taken as a whole to include policies designed to mitigate climate change and secure adaptation to it. And we've got our Climate Change Act 2008, which is fairly venerable now, but still seen as quite a progressive approach because it's quite a dynamic act which results in the Climate Change Committee, etc. Section 1 originally required the UK carbon account to be reduced by 80% against a 1990 baseline by 2050. That was amended in 2019 by a statutory instrument. It was under the May administration, so that we now have a requirement for 100% reduction against the 1990 baseline. So we have to be at the same levels. We have to reduce down from the 1990 levels to what's now called net zero. And that's quite a remarkably different target. The difference between 80% and 100%, to put it into context, the way in which the Climate Change Committee tries to analyse what that will actually require is to produce various curves and lines that assess the trajectory we need to be on. And in essence, what it means is we have to hit the 80%, the previous reduction target, by around 2035. So that amendment has halved the time to get to the 80% reduction. It means we've only got 10 years left for what we thought we had 25 years to do. So that's quite significant. And what that plays out in then is the amendments to the 6th carbon budget, which is the period from 2033. And we see that playing out in quite a lot of the case law. Sections 5 and 10 require national policy statements to mitigate climate change as well. So there's some of the main provisions that come up in the case law. Carbon budgets then. We see Secretary of State for Business, Energy and Industrial Strategy is required to set for each succeeding period of 5 years an amount for the net UK carbon account. That's called the carbon budget. And I've set out there that for the period of 2033 to 37, which is the latest one, but we've got another one coming up next year. But for the latest one, we have to reduce by 78%. So that's the point I was making, that we're basically having to hit the 80% reduction target 15 years earlier. So looking at two of the recent cases, they're both brought by the charity Rights Community Action Limited. And they're both concerned with a net zero area action plan. So West Oxfordshire District Council wants to produce a plan for a garden village where the development as a whole will be net zero. So it's going to be a sort of beacon for how development can be progressed, given that by 2050, which is not a long way away in construction terms, every house in the country is going to have to meet this standard if we're realistically going to hit that target. So they set out an area action plan with policies, and I've quoted GV3, to design buildings fit for the future, mitigating the impact of salt costs on climate change by achieving zero carbon development through low energy fabric and 100% use of low and zero carbon energy. Now, the inspectors appointed by the Secretary of State didn't like that and said the plan was unsound because it was essentially too ambitious on climate targets. So they issued their examination report on that, and in the first challenge, that was quashed and sent back for re-examination, Mrs. Justice Leven. But the government's response to that, and this gets us to the second challenge, was to issue a new written ministerial statement. So in other words, to change national policy to respond to the first judgment. So the new written ministerial statement was issued on the 13th of December 2023, and it says this: the improvement in standards already in force, alongside the ones which are due in 2025, that's the Future Home Standard, demonstrates the government's commitment to ensuring new properties have a much lower impact on the environment in future. In this context, the government does not expect plan makers to set local energy efficiency standards for buildings that go beyond current or planned building regulations. The proliferation of multiple local standards by local authority area can add further costs to building new homes by adding complexity and undermining economies of scale. Any planning policies that propose local energy efficiency standards for buildings that go beyond current or planned building regulation should be rejected at examination if they do not have a well-reasoned and robustly costed rationale. And then it goes on to give some more detail of that. So what the government was trying to do was to discourage a trend that had been growing of local authorities saying, we want to hit net zero standards in our new buildings, partly on the grounds that having different local standards was complicating things for developers, and partly because they felt it was slowing down housing overall. Rights Community Action challenged the written ministerial statement in the High Court on two grounds. The first was a breach of Section 19 of the Environment Act, which I'll come on to, and the second was a breach or a conflict with Section 1 of the Planning and Energy Act. Mrs. Justice Leven rejected the claim, and then there was an appeal to the Court of Appeal, which was earlier this year, and that's what I'll just talk for a moment about. So in this, the first ground concerns this new duty in the Environment Act in section 19. And that states that when making a policy, a minister must have regard to the minister's policy statement on environmental principles. So this policy statement is a new document, and it sets out, in lieu of being a member of the European Union, how we will continue to apply a lot of the principles of European law. It has 5 key principles: the integration principle, the preventative principle, the precautionary principle, the rectification at source principle, and the polluter pays principle. So whenever a policy is developed, the language of the section 19 is that when making policy, the minister must have due regard to all of these principles as set out in a policy statement. Now, when making the written ministerial statement, there was no dispute that the minister hadn't had regard to these principles. The minister only had regard to them having already made the written ministerial statement, and once the judicial review claim had been issued in the High Court, so some months after making it. So the question on this ground is whether that was adequate compliance with this new duty. Lord Justice Holgate, giving the judgment of the court in the Court of Appeal, said it was, and that's a familiar line of judicial reasoning. We see it a lot in the case of the public sector equality duty, the duty to have due regard to various equality factors, that if a minister only complies with the duty after the event, as long as it's still in good faith and so on, you can satisfy the duty retrospectively. The argument here was actually that the language of the duty made it very different to those kinds of duties, that what it was aimed at was the formulation of policy. And because it was aimed at something intrinsic to the formulation of policy, it wasn't just an evaluative duty that comes at the end. It wasn't just about setting the policy against a series of criteria. It was about influencing the formulation, the construction of policy. The duty was to be woven into the warp and weft of the work of the wonk. But Lord Justice Holgate didn't agree, and so there is just a new section 19 duty, which means that, as he understands it, officials in departments will have to produce assessments at the end of a process of formulating a policy, and a minister will have to sign it off if challenged. So it doesn't really do anything, but there is an appeal to the Supreme Court, so they may take a different view if they grant permission at all. The other ground was on this very mercurial act called the Planning and Energy Act 2008. It has only one section, section 1. And what that seeks to do, seemingly, is to allow local authorities to do exactly what West Oxfordshire wanted to do, which is set policies in their local development plans that impose requirements for energy efficiency that go beyond the building regulations minima. That seems to be what it says, and that's certainly the judge accepted, Lord Justice Holgate accepted, what the original draft of the Act was intended to do. However, it got amended a fair amount in the passage through Parliament. Now, the argument for the appellant here was that the written ministerial statement, in seeking to tell local authorities not to set their energy efficiency standards higher than building regulations minima, was going too far, was cutting across the powers that the Act expressly gave to local authorities to do that, and that ministerial executive action can't cut down powers that are given by Parliament to local authorities in that way. Lord Justice Holgate struggled self-confessedly to interpret Section 1 of the Planning and Energy Act 2008. He said he couldn't really make sense of it. He said he was left with the impression that the draftsman, the parliamentary draftsman, had not thought through the tensions that were created by this single section act. He said that the parties, which meant the appellant, the Secretary of State, and the Office of Environmental Protection, and 4 local authorities that had intervened, had not produced a convincing analysis which would resolve the issue of how to interpret this single section. He didn't support Mrs. Justice Leaven's interpretation from the court below, because she had had regard to Hansard, which he said wasn't available here because, in fact, the Pepper and Hart tests weren't met. But he said, in any event, what you got out of Hansard wasn't very helpful. So he didn't like what the parties said, what the judge below said, what the draftsman had drafted, or what Parliament had said about this provision. But he said it wasn't ambiguous or obscure, it was very clear. And then he said that, in fact, he didn't need to resolve what it meant, because there was another basis on which he could decide the case, which was that the written ministerial statement didn't mean what the parties had said it meant, and so it didn't cut across the legislation, whatever the legislation meant. So he didn't need to resolve that rather intriguing section. So there's an appeal to the Supreme Court. The Office of Environmental Protection are interveners. The court may be interested, but we'll have to wait and see. Okay, so that's that recent bit of legislation and litigation that I was involved with. Then we've got Finch. Everyone knows, I think, by now about Finch, so I won't spend too long in it, but just to remind you, it was about an application for planning permission to extract oil in Surrey, and the council accepted that there was an adequate environmental statement, but the environmental statement didn't assess the effects of the development in terms of the combustion of oil when extracted. In other words, when the oil is actually put to some use a long way down the line. After a very long wait, the Supreme Court, a 3-2 majority, held that the combustion emissions from produced oil are indirect effects of the project, and so had to be assessed in EIA. So another winner here, this is Friends of the Earth, Client Earth, Good Law Project. This was a Mrs. Justice Holgate decision concerned with the carbon budget delivery plan. So under the 2008 legislation, Section 13 of the Climate Change Act, the Secretary of State has to produce a report setting out all the policies by which the carbon budgets and targets will be met. And he has to make a report to Parliament under Section 14. Mr. Justice Holgate said that the report that he produced, the net zero strategy, failed to explain how the policies and proposals would in fact meet the statutory targets. And so he sent the Secretary of State away for a second go. Secretary of State had a second go and was challenged again. And Mr. Justice Sheldon held that he had failed again, and that the new plan, second version, was irrational because it was made on the assumption that all of the plans that it referred to would be delivered in full, rather than assessing how likely they were to fail and to miss their targets. So it was quashed a second time. So a third iteration was published just about 3 weeks ago, and I haven't heard anything in the winds about a third challenge. So it may be that they've made it through the third time. This was case Vince, Dale Vince, the owner of Ecotricity and Forest Rangers, George Monbiot, environmental journalist, and the Good Law Project brought a claim concerned with the failure to revise the energy national policy statements. So the argument was that the EN1 had been designated in 2011, and since then, in the 9 or 10 years since then, there had been various significant changes which merited, in fact, demanded as a public law duty that the Secretary of State at least consider whether to amend the policy statements. And so a claim was issued, and it was in fact settled on the basis the Secretary of State agreed to review. And so that review took place. So that was a settled case, but a successful climate change case. So that's another successful one. So far there's been a few successes. There's another, what I think is quite an interesting and quite potentially significant case. It was quite trivial on its own facts. It's a case called McLennan and Medway. But Mr. McLennan won, quashing his next door neighbour's extension because the extension would overshadow his solar panels. And Mr. Justice Lane quashed the planning permission because of a failure to consider the mitigation of climate change as part of the decision. And so the significance of it is that it establishes that for the purposes of planning decisions, that is a material planning consideration. So that has, to my mind, quite a potentially wide-ranging set of impacts. Then really the last in this run of the successful cases I've set out is Stevenson, which goes back a bit now. This was about the consultation on the NPPF that was issued in 2019 concerning fracking policy. And it was quashed, paragraph 209, for consultation failures. And in particular, Talk Fracking had submitted a lot of scientific evidence about fracking, which Secretary of State just hadn't taken into account. And so it being an obviously material consideration, that consultation response, that bit of the NPPF was quashed. Now, this is then banks. Now, this is not a successful claim, but it's successful in the end result in terms of the campaign around Druridge Bay. This claim was in fact brought by the mining company, banks. So in this case, the Secretary of State refused permission for the extraction of coal from a surface mine. And Mr. Justice easily quashed the decision for lack of proper reasons. And so in essence, his view was that the reasons for preferring the weight of the damage or the harm from greenhouse gas emissions over the need from a national energy point of view for coal didn't add up, and so he quashed it. But the developer got a taste of typical JR claimant medicine because the decision was retaken and they were refused permission again. It's quite a significant case because it's probably the last of coal mining decisions for the foreseeable future anyway, in the UK. Then there's a whole run of unsuccessful cases, and most of them apply well-known principles, and so are slightly less interesting than those ones that I've just set out that succeeded. So I'm going to really just zoom through these, but there's a list of them in case you're interested in climate change and want to see a list of some of the big cases. So there's the Client Earth case. This was all about the Drax power station. Secretary of State had not misinterpreted policy, hadn't erred in treating NPS as requiring him to treat greenhouse gases as having no weight in her decision. Then there was the airport's NPS case, which you'll remember went to the Supreme Court. Supreme Court overturned the Court of Appeal on the basis that the Paris Agreement was to be treated in the usual way as an international agreement. Then I've set out quite an interesting case Friends of the Earth brought about trade and export to Mozambique, but that was essentially on a deference to the Secretary of State kind of approach. It was said that the UK export finance agreement was in compliance with Paris climate change agreements, and that was a tenable interpretation, was the way it was put, and that's the threshold that had to be met. A Greenpeace case involving offshore oil and gas licensing rounds, that was dismissed. It's quite interesting because it doesn't seem to have gone further, despite the fact it applied the Court of Appeal approach in Finch to strategic environmental assessment. But despite the Supreme Court overruling that, that doesn't seem to have been picked up in time. There's a couple more here. Another oil and gas case, Mr. Justice Cockerell, a challenge to the Oil and Gas Authority's strategy, that was rejected. Then one of several Elliott Smith cases. This was a challenge to the UK emissions trading scheme, that was rejected, again on the basis of a tenable interpretation of Paris. Then I've set out another Client Earth case, which was about, that's the Drax Court of Appeal case. And then the Transport Action Network challenge also failed. Paris Agreement, not an obviously material consideration. Then Together Against Sizewell, Ben Fullbrook's just talked about, and then the Goisa case, which is about the Southampton runway. And then following that, we've got the last several Boswell cases, all about roads, all of which were rejected. And so that takes us up to time for the last questions and answer session. Thanks very much.
Hi.
James.
Hi. Yeah. So thank you. I mean, we've actually reached 12:30, and there were a couple of questions on the question and answers that have been answered in writing. So I think what I'm going to do is draw it to a close, as there aren't any other questions that are still open on the chat. So I want to just thank everybody for attending. I hope you found it useful. And as was said at the beginning, you should be receiving a link to the recording soon after this event. So thank you to all our speakers.